Hey there, Jim Hart back at you here today from the Hart Law Firm. Today I want to share with you 5 things you should not be doing if you want to make sure you get custody of your kids and you're in a contested custody case in North Carolina. So before we get to that, I want to share with you a little bit about who I am. My name is Jim Hart. I am a family law and divorce lawyer here in Cary, North Carolina, and I help people to separate amicably and to move on with their lives and get a fresh start to their lives. So today what I want to talk to you about is how to make sure you don't mess up the custody situation with your kids. Not only do you not want to mess up the custody situation with your kids, but you don't want to mess up your kids. And if you do these things, you're pretty much going to mess up your kids. And I've seen a lot of judges come down hard on clients because they've done these exact things that I'm about to share with you, which you should not do. Do not do them. So number 1, do not unnecessarily withhold visitation. This is a big one. A lot of people, they think that they know better about what's going on with their kids, and they think they're a better parent than the other spouse or their other boyfriend or girlfriend or whatever, and they want to, or they decide they need to withhold visitation. Do not do that. Judges hate that. It's just going to come back to bite you in the ass at some point later on. Don't do that. Number 2, another big issue. Do not withhold visitation or make visitation contingent on receiving child support. Child support is one issue, visitation is another issue. They are not connected in any way whatsoever. Just because somebody can't pay you child support or chooses not to pay you child support does not mean you can withhold visitation. If you do that and you go into court and a judge finds out about that, they may be more angry at you for withholding visitation than they are at this other person for not paying you child support. So do not do that. Number 3, excuse my French, but do not talk shit about the other parent to the kids. This is a big no-no. I've seen judges get so angry at clients who do this. Do not trash talk the other parent. If you trash talk the other parent, the judge is going to think that you have the mentality of a 5-year-old and that you are not capable of parenting your kids. Do not talk trash, for lack of a better term, about the other parent. You know, if your child asks you what's going on, be cordial, be nice, try and be an adult about it, and just tell them, listen, mommy and daddy are going through some difficult times. Daddy or mommy can't live here anymore. It's not your fault. You are not to blame for this. We love you. We both love you. We're both going to do anything for you, but this has nothing to do with you. We're just working through some things. That's what you got to say, even if you don't mean it, even if you think the other person is a complete you know what, it's a bad word. Do not talk trash about that other parent to your child. It's a big mistake. It gets you in a lot of trouble and a lot of hot water with the court if you do end up in court. And that kind of goes along with our 4th item here today, and that is not to put the children in the middle, no matter what happens. If you're having an argument with the other parent, don't send notes to the other parent through the child. Don't tell the other child, especially if you've got a child that's a teenager, don't tell them, hey, ask mommy or daddy what's going on with this, or why they're not paying me my alimony, or why they're not dividing up their retirement account, or why they're not doing that. Don't do that. Do not do that. So this is very similar to talking trash about the other parent, but it's a little different. Don't try and negotiate your divorce or your separation through the child. It's just a bad move. Keep the child out of it if at all possible. I mean, there's really no excuse to do that, because I will tell you absolutely, that's the surefire way to deduct visitation if you go into court, potentially lose custodial rights if it's bad enough, it's egregious enough. It's just a bad thing to do. Don't do it. And the number 5 thing that doesn't make any sense. The number 5 thing that you should not be doing is don't make unilateral decisions without talking to the other parent. There are situations that come up that might be emergency situations. Maybe there's a medical situation that you need to make a decision quickly on. You can't reach the other parent. But don't do things like change the kid's school or pull them out of school. Don't do things like leave for a weekend where you're going to be gone and you haven't told the other parent about that, even if it's your weekend for visitation. Don't do anything. Don't go taking a trip overseas without telling the other parent. Don't take any type of unilateral action like this without talking to the other parent about it. In 99.9% of the cases, the two of you are going to be what's called joint legal parents, which means both of you have a right to know everything about what's going on with that child. You both have a right to talk and make decisions about schooling, about religious upbringing, about medical decisions, about all sorts of things like that. And so if you start making unilateral decisions without talking to the other parent, it's just going to end badly for you if you go to court. So those are the 5 things that you should not be doing if you're trying to get custody of your child, and if you don't want to piss off the judge. Do not do those things. Again, my name is Jim Hart. I am a family law and divorce attorney here in Wake County, North Carolina. That's in, my office is in Cary. We also serve Raleigh and other areas in the Triangle. If you have questions, you can reach out to us. The phone number is in the show notes down below. But that's it. Have a great day, folks, and we will talk again very soon.